Hello, everybody. I'm Beat Weibel, Chief IP Counsel of Siemens. Actually, I'm now working 30 years in IP in the industry, and you are listening to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 126 of IP Fridays. Together with my co-host Ken Suzanne, I thank you for tuning in. If you are a new listener, subscribe to this podcast on your favorite podcast app. If you are a returning listener, thank you for your loyalty. Today's interview guest is Beat Weibel, Chief IP Counsel and Group Senior Vice President at Siemens, overseeing all IP and especially all patent activities at Siemens. We cover a very broad range of topics, ranging from patent quality, patent trolls, the Unified Patent Court, and much more. So stay tuned. Before we jump into the interview, I have news for you. The Unified Patent Court will likely start operation in fall this year. Austria has deposited its instruments of ratification of the protocol on provisional application of the UPC agreement. This then triggered the provisional application period, the PAP, and the birth of the Unified Patent Court as an international organization. It is expected that this period will last 8 months at least. So the UPC is expected to open doors at the earliest in September and possibly in October or November. The EU General Court upheld findings of partial invalidity of the moon boot shape trademark. In 2011, the Italian shoemaker Tecnica applied to register the 3D mark, and it was granted the following year. But now this trademark has been found partially invalid. So Tecnica will not be able to enforce this shape trademark against competitors in the footwear business easily. On January 1st, France has taken over the presidency of the Council of the European Union, and one of the priorities is intellectual property. France wants to push design reform, geographic indications, and of course the Unified Patent Court. Now let's jump into the interview with Beat Weibel. Today's interview guest is Beat Weibel. Beat Weibel is the Chief IP Counsel and Group Senior Vice President at Siemens since 2013. So he's the boss of all IP activities at Siemens worldwide, I guess. And he's also serving as the president of VPP, which is the Association of Intellectual Property Experts in Germany since 2019. And before his activity at Siemens, he was over 20 years, actually. He was at ABB for also intellectual property for a long time. And he originally received his education from ETH Zurich in electrical engineering. Thank you for being on the show.
You're very welcome. It's a pleasure to be here.
So you are a big shot in the IP world. So I have a lot of topics for you. I hope we can cover some of them at least. And one of the topics that is most interesting to you at the moment, and that's why we discussed this first, is patent quality. So patent quality is always an important issue. You see that some companies file tons of patents, and some of them have good quality and not. And some companies don't file a lot of patents, but maybe they have higher quality. So why are you so interested in patent quality at the moment?
Yeah, first of all, because this patent quality discussion, at least in Germany, has become a public discussion. And I personally think that this discussion is going into the wrong direction. And I will tell you in a minute why I think so. But from a strategic point of view at Siemens, we really try to get away from a volume strategy That means from filing as many patents as possible to filing the best ones. And quite successful in that respect, because we can prove that our patent quality, however you measure it, since we introduced this strategic change, has indeed increased quite substantially. But regarding the public discussion that is going on, as I mentioned, in particular in Germany, I think it is just the wrong basis what people are looking at. If you study the papers that were published, then the patent quality discussion is mainly driven by looking at the patents that are litigated before the German Patent Court. And as practitioners know, it's only a very, very maybe single-digit percentage of patents that are litigated, be it in an infringement court or be it in a nullity court. And as practitioners even more know that the patents that are litigated are not necessarily the best and the strongest ones. The patents that are litigated are the ones that are infringed, and that doesn't mean that they are the best and the strongest one. So already from that perspective, it's just, in my view, statistically not okay to draw conclusions from a very, very small set of patents that is litigated to the whole portfolio. And besides that, as I already mentioned, the patents that are litigated are not necessarily the best ones, but everybody knows who's active in practice that infringed patents are usually very close to prior art. They are maybe even, let's call it, trimmed to the infringing good and infringing product. So therefore, it's very natural that for these patents, a lot of state-of-the-art and prior art exists, and therefore the likelihood that the litigated patents are nullified, partially nullified, is rather high. It's maybe even higher than with other patents. So that's the first reason why I think that's an unfair discussion. And the second one is, as I already tried to mention, that there are many, many other patents, maybe 90–80% at least of the whole portfolio, that are not litigated. And a lot of them are respected without further notice, so to speak. And even other set of patents is licensed and voluntarily licensed. And I think it would just be unfair to say that the patents that are not litigated, that are voluntarily licensed, successfully licensed, that are respected without further notice are bad ones, because they are probably even the really good ones, because they don't have to be litigated.
Exactly. I guess as a lot of companies or most companies, before they launch a product, they do an FTO, freedom to practice assessment, and then they see, okay, there are patents of competitors that maybe stand in the way, and do we take the risk to infringe these patents because maybe they are easily attacked, or do we take them serious and then we better not enter this area? And as you said, maybe the litigated patents are not the best ones because they may be the competitors who are entering this field think that they may be able to remove these patents in revocation actions and these kinds. You mentioned the different factors broadly, different factors to how to measure patent quality. What can you tell us what Siemens is looking at? For example, are you looking at the outcome of oppositions, whether the patents survive oppositions, or what are the key, let's say, performance indicators or how to measure patent quality in your point of view?
Yeah, we decided not to use our internal measures because that could always be biased, and we are using an outside firm that assesses patent quality. It's a patent site. I think that's quite well that we are, let's call it a power user of patent site. And the patent site has two measures. The first is the market coverage, meaning the geographical scope of a patent or a patent application. And the second one is the citations. And I think all the factors are quite sophisticatedly weighted, etc., so that overall we feel patent site measure is quite a reliable one. Of course, it is only a proxy of patent quality that we are fully aware of, and it's just a statistical proxy, but for bigger sets of patents and bigger portfolio of patents, it works quite well in our view.
Okay, and you said you are moving away from volume filing to filing less but better patents. What are the limiting factors? Do you use, for example, do you use the same budget but spend more money, let's say, on each patent filing, or so the people who work on the patent filings have more time and can be more diligent and more careful, or how do you approach this problem of volume versus quality?
So maybe two aspects here. First of all, it's a nice experience if you have worked for a competitor of the company that you're working now. I was in contact, of course, with my predecessor, and he always said, yeah, please take care, Siemens has such a big patent portfolio, and please avoid that we get into conflicts with each other, etc. And honestly spoken, I never took that really seriously because I knew that Siemens had much more patent than ABB, but I was not impressed by the sheer volume of the patents of Siemens. I was rather impressed by specific singular patents that cover important technologies. And the second another aspect is indeed budget constraints. I mean, if you go for a volume strategy, then at some stage your budget is limited, and then you're not able to file the patents in all the jurisdictions you need. So you might have many patents and patent applications, but you might run into the problem that you have a very small geographical coverage. So that's one of the aspects. The other one is that in view of digitalization, software patents, artificial intelligence, and all these new fancy technologies that we are in, to harvest an invention and to define an invention and to patent it gets more and more complicated. Therefore, our patent professionals, patent attorneys have to spend much more time in understanding and harvest and in determining what the invention is and how it is drafted, etc. And this naturally makes sure that you focus on quality and not quantity, because you're just running out of time if you try to file everything or file a patent for each and every idea that pops up. So you really have to select, and you have to understand the technology, you have to understand the invention, put it into a framework of a business strategy, put it in the framework of a business model, and then make sure that you really cover the unique selling propositions of such a business model by the best possible patent application. And that's, in my view, a natural need to focus on quality.
Talking about quality and developments in 2022 that everyone is looking at, the UPC, the Unified Patent Court. Do you think the UPC that will likely be established within this year or opens the doors within the year Do you think that will help patent quality, or will it be detrimental to patent quality, the new court? There are some important differences to the previous procedures in Germany. For example, we don't have a bifurcated system then anymore. So one court is deciding both on patentability and infringement. And also the fee structure is very different. And there are some, of course, other differences. How do you think these differences play into patent quality or the enforceability of patents?
Yeah, first of all, I think the big advantage of the UPC is to have or to achieve a harmonized case law in terms of patentability and infringement all over Europe. And that should, in my view, certainly increase the quality of the patents, or at least the quality of the case law. And I would also expect that if you go for a uniform patent, that the investment is not so high if you compare what coverage you get, but still it's 4 times, to simplify, 4 times a European patent application, at least for the annuities. And so the investment is considerable, and I hope that applicants will seriously consider whether to go for a European patent, a uniform European patent, or not. And that should also increase, in my view, the quality of the patent applications.
And do you think the quality of the decisions of the court will be better than the decisions in litigation before this reform, or what do you expect? Like, for example, some of the important judges from the different countries are now probably moving to the UPC and serve the UPC instead of the national infringement courts. Will that be important? Or how do you think that the quality of the decisions will evolve?
Yeah, I expect qualitatively high decisions, because, as you just mentioned, let's call it the best judges are, hopefully the best judges are applying to become a UPC judge, and therefore we can hope that the decisions will be very good decisions. Whether they are better, I don't know yet, but I expect that in Europe they should be much more harmonized than what they are today.
I'm asking because the decisions in Germany are quite of quite a high quality, and it's no wonder that most of the litigation in Europe happens in Germany. Also for that reason, another reason being it's not so expensive compared to other countries.
Right.
And a lot of these judges are now moving to the UPC, so it could be that, and probably the judges in Germany are now looking forward to also having the decision over the patentability. I think a lot of the judges are looking forward to that. What is your opinion?
Yeah, I agree. I mean, would say the UPC proceedings also have some aspects, at least, from bifurcation, but it's not as, what shall I say, as mandatory or explicit as in Germany. I'm personally a confessing non-fan of the bifurcation, because I personally think that both proceedings belong together. And as we have seen in the discussion about the new German Patent Act in last year, this was the main obstacle, this injunction gap. And in a non-bifurcated system, such an injunction gap doesn't exist. And therefore, I'm really in favor of the UPC proceedings.
Yes. Let's talk about abuse of the system, or possible abuse of the system. There, in the recent years, or maybe we can even say decade, there has been something that has been evolving: the non-practicing entities, the so-called non-practicing entities that are holding patents without actually having done the research that led to the patents, or not actually using the technology in their own company and seeking licenses of possible licensors. What is your opinion? Will the UPC encourage patent trolls, or I'm sorry, non-practicing entities, or will that be something that is coming back or be enforced, or do you think that will be less interesting for non-practicing entities to use the UPC?
Yeah, my personal opinion is that the patent trolls, meaning really non-practicing entities that are kind of misusing the system to extort as much money as possible, that might be a definition of a patent troll, is still mainly a US phenomenon, because there the cost, the litigation cost, the attorney fees, the triple damages are so high that it's easy to extort money of defendants, and that will, in my view, not happen with new UPC proceedings, because the proceedings are not cheap, but they are not extensively expensive, in my view. And therefore, I don't expect that the UPC will attract more patent trolls. Maybe in the beginning there will be some test balloons of some non-practicing entities, but overall, I don't expect that the UPC will further encourage the enforcement of patents by non-practicing entities or patent trolls in Europe.
Okay, but there are also non-practicing entities that are, for example, universities or research institutes, or, for example, IBM or Siemens even, that are developing, researching technology, new technology, and then they are filing for this technology. For example, I know about IBM that they have huge laboratories for researching technology that they are never will be using, but they also have a quite an interesting licensing policy. Maybe you can tell the listeners more about your view of this. I know that you are also having very strong research capabilities at Siemens, and sometimes there will be results that you yourself, Siemens, is not using, but seek to license. What is your view on the UPC, and in this context, will it be helpful to find licensees for these type of companies that are researching new technologies and then looking for a license?
I don't think that this is specific to the UPC, but I just would like to make a general remark, which is true for Siemens or IBM or Fraunhofer. I mean, if Siemens invests in technologies and comes to the decision that this technology is out of scope of the current business of Siemens or Fraunhofer, that doesn't have, let's call it, any business at all, or Fraunhofer's business or the university's business is to do basic research, then, I mean, it's only fair that these companies, including Siemens, IBM, etc., want to get a return on their investment. And
Sure.
that be achieved by licensing out this technology or by transferring it, etc. We are doing that at Siemens as well. So we are, as I always call it, a confessing non-practicing entity as well. But we are using this money, again, specifically, we are using it to pre-finance IP protection for other technologies, for other long-term strategic technologies. So the money that we get from these licenses is again used to become even more innovative. And I think that's a fair approach.
Right.
And there shouldn't be any drawbacks with that, because it's just fair, and it's, since we're an economic company and a profit-oriented company, I think that's what we have to do for our shareholders. I personally don't think that UPC will change a lot in that respect, because it's just a harmonized proceeding and harmonized case law. But in terms of licensing out patents, I don't think it will change too much.
Well, I thought maybe you can more easily negotiate license deals that are EU-wide as compared to only licenses in certain countries where the patents exist, let's say, or can be easily litigated, let's say Germany or so. Your story just reminded me that there's of course always a legitimate reason to be a non-practicing entity, like a good one, let's say. And I just remember I was a lecturer at a university, and my story about this topic was always that IBM, when they had the mainframe computers, like huge computers, and they came out of date, let's say, and the company nearly had a bankruptcy. The boss of IBM at the time thought about all the patents and then saved IBM, because they then developed a licensing strategy and got a lot of revenue from their patents when they stopped selling mainframe computers. So I think there's always a very good reason to do excellent research, and then there must be also a good reason to profit from the research that you are doing, of course.
Yeah, exactly.
Yeah, exactly. So, okay, I also briefly wanted to touch on a topic that has been on the minds of a lot of German IP professionals. I hope I'm not boring other listeners too much, but we had a patent law reform not so long ago, and the injunction of patents, so having someone else stop selling a certain good, has been a little bit amended. So now that an injunctive relief is excluded on the basis of the particular circumstances of the individual case and the dictates of good faith. So it has been there has been introduced some wording in the injunctive relief paragraph that now allows defendants to defend themselves, so they don't have to stop selling certain goods or offering certain goods. What is your point of view, or your ideas about this change in patent law in Germany?
Yeah, actually, I've been in the discussion and following the discussion very closely as well. Honestly spoken, I'm not really happy about the changes because of two reasons. But on the other hand, and I will mention them in a minute, but on the other hand, it's amazing that if you talk to Supreme Court judges, they say, "Oh, there won't be any change at all. We will do our case law anyway." So I mean, creates, in my view, it creates some tension, because the legislator obviously wanted to have some change, and therefore they changed the law. And the judges say, "Oh, no, come on, there won't be any big change." So it may be interesting how it comes out. But if you read the change to paragraph 139, what immediately struck my eye is that if you compare that, for example, with the ruling in the UPC agreement, or in the French patent law, or in the UK patent law, there is one big difference. And the German connecting factor or connecting point for this disproportionality consideration is already the claim in German, in Anspruchnahme. And in France, UK, and at the UPC, it's the enforcement. So there it's clearly written that the court may issue an injunction. And in the new paragraph 139, it's already the claim, which can, in my view, only mean that already, I'm exaggerating now a little bit, but already sending a warning letter to a company could create unfair disproportionality and would be forbidden. And with that, I personally think the legislator has just gone too far, because in one of the drafts, the connecting point was also with the enforcement by the court, which in my view would have been the correct connecting point for this disproportionality considerations. And the second reason why I'm not so happy with is that disproportionality considerations are even possible for third parties. And as a patent owner, you're just not in a position to oversee the whole value chain, whether in some part of the value chain there might be a small company that has to close down because it's not able to deliver any or supply any goods anymore. And I think that also goes too far. But as we learn from the Supreme Court judge, there won't be any change. I doubt, let's say, maybe they are right in terms of case law and decisions that come up to the German Bundesgerichtshof. But in my view, the big problem is that the signal that you send with this change, because already the claim, meaning the Inanspruchnahme, has to be proportional, then this will used or can be used as an argument in licensing negotiations. And with this change, you just discourage respecting patents, and you just discourage honest licensees, because there is no reason at all why you should respect the patent, because at the end you're only obliged to pay a license fee, and why should you respect the patent if you have the chance that you can claim disproportionality or something like that? So I think at the end, in my personal view, the wording is not very good, and from my perspective, it weakens the German patent law too much.
I agree with you 100%. Thank you so much. I have a provocative question that maybe would be interesting for you also to answer. Now that we are moving to the UPC, and I expect a lot litigation moving from national courts to the UPC, and especially the second tier and third tier companies in the automotive industry might be using the UPC because of this a little bit harder wording. How relevant will be the German courts in the future when deciding on patent infringement, if the patentees, the patent owners have a much better paragraphs to work on at the UPC?
Yeah, honestly, I have no feeling, but let's say before the patent reform, I would have expected a quite substantial number of patents to be opted out, because patent owners wanted to stay within the known proceedings and the quick and strong patent proceedings in Germany. Now with the weakening, you might be right that less opt-outs will happen, and that maybe some of the patent owners will be happy to go to the UPC or even prefer to go to the UPC. I have no feeling at the moment. I think we have to see how it develops.
Yes, let's see. It will be very interesting to see, especially which fields of technology, which companies are using the UPC most and which ones are not. I'm very interested in the developments. So I wanted to touch on something that you mentioned in the beginning, in the artificial intelligence generated inventions. If an artificial intelligence is generating an invention, there are all these Davos procedures all over the world. Can the AI be inventor? Most of the countries decide, most of the legislations decided that it's not possible for an AI to become inventor, except I think Australia and South Africa at the moment. And on another aspect would be who should own the inventions generated by AI? Should that be the person who's pressing the button, or should that be who should be the owner of the of these inventions? I think you have a very clear opinion about this, and that would be very interesting for our listeners.
Yes, indeed, I do, and I'm happy to share that with you. I think to start with, I would say it is a fact that at some stage we will have such artificially intelligent created inventions, because we already see artificially intelligent created pictures, music, articles, books, film, designs, etc. And in my view, it will only be a question of time when we see the first really AI created inventions. Just to share some information from Siemens, as regards the electronic design of printed copper boards, I mean the electronic circuit, so to speak, that's at Siemens mainly done by an artificial intelligence system. And I could very well imagine, for example, if in such a system a new low-pass filter or high-pass filter or whatever, and then another electronic topology is created by such an AI system that is new and inventive, then we would have exactly AI created invention. And then we are confronted with the problem that who should be named as inventor. I mean, as long as human beings are kind of the trigger or the involved in creating such an invention, I don't think that we really have a problem here. But if the creativity, the creative act that is needed for being an inventor is really done by an AI system, then we have a problem, because it would be not fair and not truthful to name somebody who just pressed the button or used the computer, etc., because he or she not really creatively contributed to the invention. And therefore, I'm proposing for cases where it's not possible to determine which human being creatively contributed to an invention, to attribute the inventor rights to the company that used that, because that would be much better than attributing it to a anonymous AI system that cannot have any rights, that has no duties, that cannot assign anything, etc., but to attribute it to the company. And by the way, in Germany, we already had such a system in the 30s, I think. There was the concept of Betriebserfindung, company invention, exactly for this case where it was not able to determine who creatively contributed to the invention. And that could be, in my view, a way to resolve the problem. And I also feel it's the much better way than what the Davos proceedings tried, because as I mentioned, a AI system cannot have any rights, has no duties, etc. Therefore, this system shouldn't get any inventor rights. And on the other hand, to give inventor rights to a person that not creatively contributed to an invention would even be much more unfair, because then this person would be remunerated for an invention that he or she didn't even do. And if I may say a few words about the DABUS applications, I mean, it's great that at least somebody tried something with these applications and kind of fired the whole discussion. But honestly spoken, I think it was a nice try, but in my view, it's the wrong approach. Because if you read the two applications, the food container and this let's call it blinking light or whatever it is, carefully, then for me, I never understood why this should be an AI-created invention. It could very well be a human-created invention, and there is no indication whatsoever that this invention could only have been created by an AI system. So therefore, in my view, the patent offices have no chance then to reject it, because there is no way to see for them that this couldn't be created by a human being. And then if you don't nominate an inventor, then we know that the legal consequence is a rejection. So I would say European Patent Office didn't have any other chance than to reject it. What I could rather imagine for the case that I tried to describe, where the creativity is really carried out by an AI, self-learning AI system, that the applicant files an affidavit stating, I'm sorry, I cannot determine a natural person as inventor. Therefore, I nominate myself as a company as being the proxy for the inventor for this invention. And therefore, I mean, there doesn't need to be an assignment anymore, because the company already owns it. And that would be much, much easier than to allocate inventor rights to a system or to a non-creative human being, and then try to transfer it to the company, which doesn't work if the rights are allocated to a system, because there's no way to do an assignment. And if it is with the non-creative wrong person, I think that's unfair as well.
Right, especially in view of the German Employers Inventor Act.
Exactly.
And remuneration connected to this. So we just talked for a long time now, and before we wrap up the interview, I wanted to ask you like a final question. What do you think, in your opinion, are the biggest challenges in the field of IP in 2022?
Yeah, actually, if I think what's the biggest challenge for the future in terms of intellectual property, it's certainly these artificial intelligent created inventions. But maybe the problem is a little bit overstated, because there will be certainly a few cases, but I doubt whether there will be extremely many cases that have this problem. Then another challenge is certainly this patent quality discussion and the enforceability discussion, which is very prominent, and where we, in my view, should make sure that we are not weakening the patent system because of wrong assumptions, by looking at a kind of wrong set of patents that has not the biggest quality, because these conclusions cannot be driven, as I tried to mention. But the biggest challenge, honestly spoken, in particular in my position, is regarding the fight, the economic fight between US and China, this decoupling discussion, because this has clear implications on intellectual property. on where to research, where to develop, what to own, etc., how to set up a IP ownership scheme, how to set up R&D activities, etc. And that's something I'm currently looking into. I have no final answer yet, but I think for international business, that will be a huge challenge, how to make sure that international globalized business is still possible, even when the two biggest players start to kind of decouple themselves, and to understand what implications that has for intellectual property and intellectual property ownership, in my view, is a really big challenge that we have to tackle in the next years.
So you just mentioned the decoupling. What does that really mean for Siemens or for Europe? The between like China and US, the decoupling. We are in the middle, right? We are somewhere in the middle. What does it mean for us?
Yeah, I think it would be a huge opportunity and huge chance for Europe and for European companies, because, as you mentioned, we are in the middle and we might have the opportunity to serve both sides, the US side and the Chinese side. And therefore, I really hope that in the political discussions, we get away from these dogmatic discussions about inventorship and injunction and competition, etc., to strengthen the European IP system in a pragmatic way, to being able to profit of this opportunity and of this chance. Because at the end, I think in order to not to get between these two fronts, the Chinese and the US fronts, we need to strengthen the European technological sovereignty, and that could be done with a strong and with an open-minded IP system, where we are open for example, artificial intelligence inventions, where we have a European software register to register our copyrights, etc., etc. But I'm really sorry that sometimes I feel the politicians rather love dogmatic discussions than pragmatic discussions that would help industry and economy.
Unfortunately enough, but you are president of the VPP. Maybe you can you can utilize this function toward the politicians, or to get in discussion with the politicians. Okay, but this was a really, really fun interview for me, and we covered a really broad range of topics. I'm very grateful that you came on to our show, and yes, thank you very much for being here.
You're welcome. It was my pleasure, and have a nice weekend.
Thank you so much.
Thank you. Bye-bye.
Bye-bye.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.